After the interruption that we have made by receiving the landmark judgment of Supreme Court, we again want to go back to our series of lectures on international law, and in that regard we would like to discuss the very sources of international law. So, as to the various sources of international law, we found the first one, that is custom, and the second one, the treaties, and the third one, the general principles of law, and the fourth one, the judicial decisions, and also the fifth one, the contributions made by international law jurists, and the sixth one, that is the General Assembly resolutions. So, as regarding to customs, which is the first definite source of international law, and as it is being defined by Professor Oppenheim, customary international rules evolved through practices and usages of nations and their recognition by the community of nations. And Professor and international jurist J.G. Stark defines it as the usages where in initial stage of the customary international rules and custom begins where usages becomes general customary rules, and in that regard they provided certain examples of the usages as the maritime laws and diplomatic privileges and immunities. So, any customary rule must to become a source of international law must meet the following criteria, and those criteria as its duration of continuity and its uniformity, its consistency and generality of such rules of customary rules of international law. So, in that regard, we would like to cite certain important leading cases, as in the Anglo Norwegian fishery case of 1951 and the North Sea continental case of 1969, and the leading important case United Kingdom versus Ireland fisheries case of 1974, where the International Court of Justice at Hague held the views that any practices relating to continental shelf or rules to airspace, if have substantial uniformity and consistency, shall be accepted as customary rules of international law, but they did not accept laws developed regarding diplomatic asylum. Also, in the United Kingdom versus Ireland fisheries case in 1974, the International Court of Justice at Hague held the principle of general stability by the state as customary rule to become a part of international law. And they made a division of customary laws, and in that connection, the laws of treaties, law of sea, laws of diplomacy were considered as part of customary rules or laws developed in international law. So, another important thing we found in that connection regarding the rights of USA nationals in Morocco in 1952. And in that connection, we would like to point out that the customary rules are divided as general customary rules and also particular customary rules. And as regards to general customary rules, the basic rules pertaining to the law of treaties, law of the sea, law of diplomacy are general customary rules of international law and are binding on all the nation states. And in regard to particular customary rules, these rules govern two or more states or regional community of states. In the case of rights of the nationals of United States of America in Morocco in 1952, the International Court of Justice at The Hague held the validity of particular customary rules, and that was prevailing among the American states, which includes also the South American states or the Latin American countries, including Mexico, Panama, Cuba, etc. And the very important second source of international law is the treaties. And treaties are otherwise also known in the name of agreements, conventions, accords, covenants, or protocols, either between two or more states or between international institutions and organizations. And as such, we want to categorize certain important treaties such as the Hague Convention of 1899 and 1907, the Vienna Convention of 1961 and 63, so also the Geneva Protocols of 1925, as well. Treaties are generally divided as general treaties and particular treaties. General treaties as because in due course large number of states became parties to these treaties. So these kind of treaties are otherwise called general treaties. And in regards to particular treaties where the parties are two or more, then it would be considered as a particular treatise. And in that connection, we would like to cite certain agreements or accords raised in between two countries, such as we could cite an agreement in past raised in between India and United States of America during the Prime Ministership of Dr. Manmohan Singh, and that was regarding the civilian use of nuclear agreement, and that was considered as an particular treaty. And as we found that besides that extradition treaties, trade and commerce related treaties among two countries or more than two countries are also considered as particular treaties. And even Article 38 of the Statute of International Court of Justice empowers to the World Court to apply the rules laid down in any of the two kinds of treaties that we have discussed above, the general treaties or regarding particular treaties. And now we want to go to the third important source of international law, that is general principles of law. And under general principles of law, we found res-judicata, equity, presumption, and Estopple are the different principles of law, and these were held valid by the International Court of Justice in some important leading cases such as Mosul boundary case in 1925, also in Lotus case in 1927, the Eastern Greenland case of 1933, then diversion of water from Muse case in 1937, also the Republic of Indonesia case in 1949, where Indonesia declared independence in 1948 against the Portuguese colonial rulers. And also we found the application of the general principles of law by the International Court of Justice in Corfu Channel case in 1949, and also Article 38 of the International Court of Justice statute recognize this principle of laws as applied by the International Court of Justice to uphold res-judicata, equity, presumption, and Estopple as the important sources of international law. And now we'll want to go to the fourth important source, and that is the judicial decisions. And such judicial decisions as delivered in particularly in the case of Paquet Habana case of 1900, and also the Barcelona Traction case of 1970. So the British prize courts and also the permanent court of arbitration, they held the very application of those international principles of law and also the customary rules And even Article 59 of the Statute of International Court of Justice, which recognize all the precedents held by the courts and the views of international jurists also we want to discuss. And exactly regarding international jurists, we would like to discuss the Calvo doctrines, also the Drago doctrines and the contribution of Crucius, who is considered as father of international law, also battled the French international jurist, and also Weinker, Schuck and Blanchils, etc. So, in Pacut Havana case in 1900, in the Barcelona traction case in 1970, International Court of Justice clearly upheld the doctrines developed by Calvo, an Argentinian jurist, and Dr. Drago, the then Argentinian foreign minister, and their contribution for the development and growth of international law was considered by the International Court of Justice as vital sources developing international law. So also International Court of Justice held the views of eminent international law jurists and philosophers like Grotius, Vattel, Weinker, Schuck, and also of the workshops, Fillmore, and also the Swiss German jurist Blanchils and the workshop, David Field and the Italian jurist Pasquale Fiori. In those important leading cases such as the Muse case in 1937 and the Colombian Peruvian asylum case in 1950, also in the real incident case in 1959. So, the International Court of Justice clearly recognized and offered the contributions of these international jurists and philosophers who made the outstanding contribution in the field of international law. So, such important contributions of Calvo, the Argentinian publicist and jurist, and Drago, the Argentinian foreign minister, and Grotius, who is considered as the father of international law, and Vattel, the French international jurist and philosopher, also Weinker, Schuck, and Blanchels, as also the International Court of Justice held their views in its landmark judgments such as the Muse case in 1937, the Colombian Peruvian asylum case of 1950, also in the aerial incident case in 1959, and the last most important source that we would like to discuss, the General Assembly resolution, and regarding the views of international jurists and international law philosophers Explicitly, Article 59 of the Statute of International Court of Justice at The Hague recognized the judicial decisions delivered by the International Court of Justice or by the domestic municipal courts, and also the views of jurists as a definite source of international law. As we found the very provision under Article 59 of the Statute of International Court of Justice, and the last of the sixth definite source of international law is the General Assembly resolutions, and this in this category, the first one that we would like to discuss, the Universal Declaration of Human Rights in 1948, which was enacted on December 10, 1948, and also it came into effect on 10th December 1948, and which is being celebrated in every year as Human Rights Day. And besides that, many such resolutions enacted by the General Assembly by its resolutions such as the prohibition of use of nuclear weapons in 1961, then declaration on granting independence to colonial countries in 1960, then the permanent sovereignty over natural resources resolution in 1962, then the exploitation and use of outer space resolution in 1963, then the resolution on defining aggression in 1974, or such General Assembly resolutions which became one of the important sources of international law. And as such, Permanent Court of International Justice, before the formation of United Nations Organization, as it was formed out of the League of Nations, which was formed in 1920, and the International Court of Justice in 1945, after the United Nations Organization was established and formed. So their role in interpretation of customary rules, treaties, and the application of general principle of law as sources of international law were outstanding contribution made by the International Court of Justice and the Permanent Court of International Justice. And Article 38 of the International Court of Justice Statute and Article 59 of the Statute of International Court of Justice provide for interpretation of judicial decisions and works of jurists and international law philosopher as a definite source of international law. So, in this context, we would like to comment that besides custom treaties, general principle of law, and judicial decisions are the contributions made by the jurists and international law philosophers, and the General Assembly resolutions definitely the International Court of Justice, and before it, the Permanent Court of International Justice, played vital roles in their interpretation of the very application of customary rules, and those rules agreed upon by or through bilateral treaties or multilateral treaties, and also they made application of the general principles of law which were developed as such. The principles of res-judicata, equity, presumption, estoppel as definite sources of international law. So also they recognized the judicial decisions of the International Court of Justice and those domestic and municipal courts, decisions relating to international law interpretation, and also the contributions made by international law jurists and philosophers, which itself is recognized under Article 59 of the Statutes of International Court of Justice, and has such finally General Assembly resolutions contributed a lot in the growth and development of international law. Last but not least, we found there are different sources as important as custom treaties, general principles of law, judicial decisions, and the contribution of the international law jurists and philosophers, and the General Assembly resolutions. So finally, we want to conclude that international law came into a stabilizing and lasting influence on the international community by its due growth and development due to these above mentioned different sources that we have just finished. So, the very contribution of these different sources in relating to the very evolution and development of international law, and till now we found these contributions are definitely outstanding and everlasting contribution in the very development and growth of international law, in especially in governing both bilateral relations, so also the relations pertaining to regional conventions or regional groups such as the Organization of American Union, Organization of the African Union, or among the European Union nations, or among the Arab League, and also among the Association of Southeast Asian Nations, and also that exactly the North-South dialogue, and the big nations such as Brazil, Russia, India, China, and South Africa, and also among the SAARC countries in a regional level, such as the South Asian Association for Regional Cooperation. So, definitely, the various sources that we have discussed, they left lasting contribution and influence on the very development and growth of international law.